As is traditional with our program, is the ethics panel. And with us today to lead that panel is Lara Bazelon. Lara is an associate professor of law at the University of San Francisco School of Law, where she directs the criminal and juvenile justice and racial justice clinics. She was a federal public defender for 7 years in Los Angeles, following a clerkship for Judge Harry Pregerson on the Ninth Circuit Court of Appeals. Her scholarship explores issues of the intersection of criminal law and ethics. She's a contributing writer for Slate. Her op-eds and essays have also been published in the New York Times, the Washington Post, the Los Angeles Times, the San Francisco Chronicle, Politico, and her book, Rectify, A Story of Healing and Redemption After Wrongful Conviction, will be published in October of 2018. And I would invite Professor Bazelon to introduce her panel to those in attendance. Thanks.
Thank you very, very much for staying for the last panel. So every year we have the ethics panel last, and I'm going to try not to read too much into that, other than to say I'm very happy that everybody stuck around and that there are going to be drinks afterwards. So we have an incredibly juicy topic to talk about. We're talking about these two explosive crime lab scandals, both of which happened in Massachusetts, one in Amherst, one in Boston, and they had tremendous kind of cataclysmic collateral effects. We're talking about two rogue chemists in two different laboratories who really wreaked a lot of havoc in the criminal justice system. And we're very fortunate to have three people here today with us who can speak directly to both scandals because they've been personally involved in the work of trying to clean them up and try to get some remedies for the people who were adversely affected. So I want to kind of jump right into this conversation, which I think is going to be extremely interesting, and introduce them. So starting from my left, we have Vince DeMore. He is Chief Chelsea County District Court at the Suffolk County District Attorney's Office. And Vince was really the point person on one of the scandals involving a rogue chemist named Annie Dukin. And Annie Dukin, as Vince will go on to describe to you, essentially falsified drug results. And her motivations are a little bit murky. She was certainly the most productive person in her lab by a factor of 3 because she wasn't actually doing any testing, and instead she would come in and testify to tests that had never been performed. And as a result, thousands of convictions had to be reassessed and dismissed, and Vince took on the role really of identifying and assessing and resolving more than 16,000 of those cases. And so we're going to start with him, and he's going to talk about kind of the responsibility that fell on him and how he handled that situation, which he handled it so well that actually he just received a special recognition award from the Suffolk County District Attorney, Conley, and also a shout out from one of the justices on the Massachusetts Supreme Court. So we're very lucky to have Vince DeMore here with us. Also here with us is Jessie Amunson. She is a partner at Jenner Block. She is also the co-chair of the law firm's appellate and Supreme Court practice, and she has tremendous experience briefing and arguing complex issues of constitutional law and statutory interpretation. She authored the amicus brief in the second crime lab scandal case that we're going to be talking about involving a rogue chemist named Sonia Farrak. And on behalf of a number of law professors, including myself, she wrote a really eloquent and fiercely argued brief that went up with the actual brief that was brought by the people representing all of the wrongfully convicted folks, arguing essentially that because what happened was not only disastrous in terms of what happened on the ground, but also because there was actually a systemic cover-up by people in the Attorney General's office who were assigned to get to the bottom of it and rectify it, and rather than do that, they committed their own fraud on defense counsel, on these defendants, and on the Superior Court. She is taking the position on behalf of law professors that there should be some kind of really major sanction, and actually specifically monetary sanctions against the Attorney General as a deterrent. So she's going to talk more about that, and also about just the facts and specifics of the Farrak scandal itself, which are quite extraordinary. And then finally, last but not least, we have my friend Kevin Curtin. So he is Senior Appellate Counsel for the Middlesex District Attorney's Office. He's an ethics expert, particularly in areas of Brady and grand jury practice. He is also a member of the American Bar Association's Criminal Justice Council, which is the main policy-making body of the criminal justice section, and he really is an expert on best practices. And so Kevin is going to weigh in kind of from a 10,000-foot view and talk about what we do now in the wake of what we know and what he's been doing proactively to institute best practices in prosecutor offices so that they are better prepared to deal with situations like this when they, unfortunately, as they sometimes do, occur. So these are my wonderful guests, and thank you very much for being here. So Vince, I'm going to start with you, and if you wouldn't mind just sort of explaining maybe some of the facts and specifics and then how you came to be the point person in the Annie Dugan case.
Sure. So I was pleased as we were walking in. I saw that there was a cocktail reception afterwards because the prosecutors in the room, I guarantee, are going to need one after they hear the story. Annie Dugan was a chemist at the Department of Public Health in Massachusetts, and she worked out of the laboratory located in Jamaica Plain, which is a neighborhood in Boston. Virtually all narcotics or seized drugs or found drugs or drugs as a result of suicides, anything recovered by the police, would be sent there for analysis if it came from one of the municipalities. The state police have their own separate lab, which is a fully ASCLD accredited lab, so many of the problems that we'll talk about today don't apply to them at all. She was one of the chemists there, and they obviously had enormous backlogs at all times, and what she ultimately ended up doing, in terms of just to cut to the chase, is she would do something that's called dry labbing, which is when you look at something and you say, yep, looks like Coke to me, and you fill out the paperwork as if, in fact, you had done the reagent testing, the sort of front half testing. She would then prepare an aliquot to go to the mass spec. It would go through mass spec correctly, appropriately, for the most part, and the results would come back, which 99.9% of the time conformed with what she guessed the substance was. Keeping in mind, this is pre-fentanyl, right, when frankly our police ability to discern what's heroin versus fentanyl, what's cocaine even, has really gotten pretty bad. I find their guesses tend to be incorrect a lot. So pre-fentanyl, you could kind of get away with this, so to speak, and not be wrong very often. And at that point, she sort of was stuck with a decision to either sort of announce that, in fact, she had not done the front-end tests correctly or at all, or make the results of the mass spec conform with what she said it would be in the first instance. So to that end, she would take known, let's say she said it was cocaine, it came back as sometimes heroin, maybe non-narcotic, maybe some combination of both. She would take a known sample of cocaine, add it to the aliquot, and then send it through mass spec so that the results would conform with what she indicated it would be. That happened, as near as we can tell, in about a dozen instances. Like the actual times in which the results were changed was exceedingly small. Obviously, more than one is too many, but did not happen a ton. That was revealed to us in August of 2012. When essentially she confessed. Her employees, her coworkers, I should say, who didn't like her very much, many of them, because she was so much more productive than them.
Go figure.
When the state police took over the lab as part of a reorganization of the way the drug testing was done, they began an audit and they began a real top-to-bottom evaluation of the lab. Because, as I said, they were ASCLD accredited and really were not interested in taking on this nightmare of a facility without first making sure that everything was going to check in well and mesh with their own accreditation requirements. And it was only within a couple of months that the full sort of scope of her misconduct was revealed after they began that, and she admitted to engaging in the dry labbing. From there, the litigation that flowed from it really flowed in I'd say 4 distinct phases. The first was to deal with custodial cases, so people who were either serving a sentence or held on a bail. Virtually everyone was released on a personal recognizance, many of which, particularly if they were serving a state prison sentence, were released with a GPS monitoring device. The second phase was essentially, so what do we do about this as a question of law? What's the legal standard to be applied? Because they're not really cases of actual innocence, right, which would be easy. Those are easy calls. they're sort of procedural defects to the plea process. And the case that I maintained was on point was a case out of our First Circuit called Ferrara, which involved La Cosa Nostra and had a Whitey Bulger connection, of course. And in that case, the chief prosecutor on the case essentially withheld exculpatory evidence that would have been the sort of thing that would have not allowed the guy to plea. He wouldn't have pled guilty to the RICO and charges and what have you. So there the court held that when there's egregious governmental misconduct that antedates the entry of the plea, and that misconduct is material to the plea, it negates the voluntariness of the plea. So that's the standard that we asked the SJC to apply. And ultimately they did with a catch, which was that they said that proving the nexus between the misconduct and the defendant's individual case was too difficult. So as a result, they created a conclusive presumption of egregious governmental misconduct in any case that she touched. And she was at the lab for about 10 years before she was ultimately terminated.
I just want to interrupt really briefly and just say it seems like that standard, whether there was a nexus or not, that was a subject of some degree of battle between the district attorney's office and the folks representing the convicted defendants.
So I think what ultimately came to be called the Scott standard. That was the Massachusetts case with Scott, but originally the Ferrara standard. I don't think there was a huge disagreement that was the standard to apply. I think the question is what nexus was required, and I think the defense position was if she was involved in the case, there's your nexus. And our position, which we thought was in line with the Ferrara case, is like, well, if she engaged in misconduct in your case, there's the nexus. It's not sufficient that she merely be involved in the case. And when the SJC created that conclusive presumption, they resolved that question really in favor of the defendants by sort of relieving them of that particular evidentiary burden, which was a big deal, right? That's you go from maybe like 12 people who can successfully proceed with a claim to 20,000. The federal court did not do that. The federal court maintained the Ferrara standard and said you've got to show that she actually engaged in this misconduct in your particular case, and that remains the state of the law in the First Circuit on all of the federal cases that she was involved in. The second and third phase of the litigation is what we call Bridgman 1 and Bridgman 2. In Bridgman 1, so the defendants get this great evidentiary presumption. All they got to do is show that they wouldn't have pled guilty had they known. The SJC also said, in Commonwealth, you can't even argue that you would have retested the drugs. You can't argue that you would have done something to cure the defect in your case. You're stuck with the case as it existed at the time of the plea. You'd think that these should be sort of like slam dunk cases for people. But the reality is the vast majority of folks, when they plea, because very few drug cases go to trial, as we all know, when they plea, do so with enormous charge concessions. And so the Bridgman 1 claim was that, well, the reason why you're not seeing this rush of folks to the courthouse is because they're scared that if they successfully challenge their plea, that they're all of a sudden going to go from having successfully served a 3 to 3 in a day to looking at a 15-year state prison min-man, and you'd be crazy to do that until you really need to, like until the feds have indicted you as a career criminal or something like that where it matters. And so what the SJC did there was they created something that's called the Bridgman cap, which essentially said that the defendant can't do any worse than what they got the first time around. So they said that the government cannot reinstate the charges that were dismissed in consideration of the plea, cannot seek any subsequent indictments that may sort of cure those charge concessions, for lack of a better phrase. And so after that, once again, there was not a big rush to the courthouse. Nobody came. So then the claim was, well, nobody came because you didn't tell them that they had these claims. And I'm sure we'll talk more about notice and identification a little bit later on in terms of that whole process. But in the end, what the SJC did in what's called Bridgman 2 is they changed what, I remember one of the amicus briefs described it as the choice architecture, which I thought was a nifty phrase, of the defendants. And they said, well, we're not even going to make the defendants come to the courthouse. Government, you're going to give us a list of the cases that you, A, would re-prosecute if the defendant's motion for new trial were allowed, and can re-prosecute. It has to be a viable case, meaning that narcotics weren't destroyed and available for retesting, the police officers are not dead or otherwise indicted in the meantime, and you can proceed with the case. So you're going to produce that list to us. Everybody else gets dismissed with prejudice. And by the way, you better be judicious in your exercise of discretion on that list, because if it's a little too long, we might have to revisit this case again. So at the end, the several district attorneys' offices whose cases were impacted by Dukin's misconduct produced a list which in total was around 300 cases that we deemed re-prosecutable, and there were 20,000 that were dismissed. Which, I'll be honest, tickled the SJC. They thought they were expecting a way bigger number than 300 statewide. And then for those individuals, the 300 cases got in-hand service of a letter that was drafted by the defense bar with assistance from the court and some other experts, and everyone else received service via first-class mail of a similar letter, but shorter because their case is already dismissed. So that's essentially the course of conduct with Annie Dukin. You may be asking what happened to Annie Dukin. She was sentenced to 3 to 5 years state prison, which she has concluded that sentence at this point. I think she has some from and after probation also. And I think, and you're going to hear in a moment about the Farrak case, and I think the biggest distinction is that when I look at the way the Dukin cases were handled, that was sort of like litigation in the sun. Right? Everyone was competing and playing with the same information, right? So as discovery came in, it was immediately turned around, provided to the defense bar, the defense teams. If there was something that we thought was not appropriate to go out, I mean, for instance, every email from the Department of Public Health was produced, right? And we all, have co-workers who email things that don't belong on, work email, not necessarily bad things, but things about like their kids and health issues and things like that. They would be redacted, but they'd be clearly redacted. Not like I'm going to throw the page away and not tell you about it, but, black line redacted. And that way everyone could sort of litigate from a position of equal strength and fairness. And from what you're going to hear in a moment about Farrak, not necessarily the case for the western part of the state.
So I think that's a good segue, Jessie, into talking about what happened in the Sonia Farrak case, and you can just start us off because you're so intimately familiar with what happened.
Sure. So Sonia Farrak was a chemist at the Amherst lab in the western part of Massachusetts, and Ms. Farrak had a pretty severe drug abuse and drug addiction problem while she was working at the lab. And at some point, and that is a big point of contention in the case, at some point she began actually stealing samples from the lab as well as using the standards at the lab. And so it really was kind of amazing that the processes that they had in place at the lab were, so minimal in terms of security. It was like sort of refilling the vodka bottle in your parents' liquor cabinet with water. That is essentially what she was doing, is just refilling these samples with non-substances, and this was going on for quite a while. In January of 2013, one of her coworkers discovered samples missing, and she, later admits she was smoking crack cocaine while at work, etc. So one of her coworkers discovered some of her samples were missing. They were discovered at Farrak Station. She was arrested. Drug paraphernalia was found at her station. And then a search of her car ensued. Her car had lots of drugs paraphernalia, and also what later became called the mental health worksheets. So she had been going to therapy during all of this time, and there were worksheets in there where she was documenting her cravings for drugs, how she was handling her cravings for drugs. And it was pretty apparent from these worksheets that they were from at least 2011 and possibly even earlier than that. So, however, the prosecution's theory, so when this came to light, of course, a lot of defendants began seeking discovery and to try to vacate their convictions. And there were two cases called Cotto and Ware that were going on, where two defendants were trying to vacate their convictions because Farrak had signed their drug certifications. During the discovery process, there were the Attorney General's office, there was kind of parallel litigation going on. So there was a prosecution of Sonia Farag herself going on, and an Assistant Attorney General named Ann Kazmarek was put in charge of that. And then there was also a very junior, brand new Assistant Attorney General named Chris Foster, who was put in charge of responding to all of the discovery requests from the various defendants who were seeking to vacate their convictions as being tainted by the work of Sonia Farag. So at some point, a determination was made that they were not going to turn over these mental health worksheets. Not only did they not turn them over, at one point, they expressly represented to the court that everything that was non-privileged had been turned over. So a major point of contention, of course, in the Cotto and Ware cases was when the misconduct began. So Cotto had pled guilty, I believe, in 2009, and the prosecution's or the government's theory was that the misconduct was very limited in nature, that it essentially occurred in the latter half of 2012, immediately prior to her arrest in 2013. So the court actually made findings of fact and denied Mr. Cotto's motion to vacate his conviction based on the fact that he was outside of the time when the misconduct was occurring. And obviously those findings of fact were not informed by these mental health worksheets that would have shown that the misconduct was likely occurring much earlier than just the latter half of 2012. And then at some point in 2014, while the Cotto and Ware cases were on appeal, the defense bar continued very aggressively trying to seek discovery and trying to get access to the materials that had been recovered from Ms. Farag's car. And eventually, these mental health worksheets did come to light. Yet, even when they came to light, the Attorney General's office, which was defending the court's findings in Cotto and Ware on appeal, never informed the court that these new things had come to light. So as of 2014, they were still defending these convictions based on the fact that the misconduct was limited in time to this period immediately prior to Farag's arrest. In the Cotto and Ware cases, when the Massachusetts Supreme Judicial Court upheld the findings, however, it did order a further investigation to take place because an amicus brief actually had been filed pointing out that these mental health worksheets had come to light. And so on further review, an evidentiary hearing, the judge in the Cotto case then issues these just astounding findings of fact about the whole course of conduct, both Sonia Farag's course of conduct, but also the course of conduct in the Attorney General's office and the decision-making process that went into the decision to withhold the mental health worksheets. And the findings of fact actually call it a fraud upon the court and call it deceptive, and they're really pretty extraordinary in terms of what you normally see a court doing about a prosecutor and specifically about the Attorney General's office. And so similar to the Dugan scandal, the remedy that was applied as relates to the convictions were that any conviction that Sonia Farag had involvement with was vacated. But there was a motion to vacate any conviction that went through that lab during that time period because of the idea that it had tainted that. So there was the vacate the convictions remedy. And then also what the counsel representing the convicted defendants argued was that there should also be sanctions against the Attorney General's office because in addition to it's sort of a whole separate level of misconduct, in addition to the conduct that was going on at the lab, there's also all this prosecutorial misconduct. And the Attorney General's office in the recent argument in the Massachusetts Supreme Judicial Court essentially said that they don't believe that institutional sanctions are warranted, that they have instituted various training programs, et cetera, and that this won't happen again. So essentially the remedy runs basically against the district attorneys who secured the convictions and the Attorney General who actually was responsible for the misconduct that allowed people to stay in jail longer than they should have, frankly, or to serve out their sentences or be on probation, et cetera, longer than they should have, essentially gets away scot-free. So that was the subject of our amicus brief, which we'll, I'm sure, talk about later.
Yes, we're going to pick back up on that, and I think it's actually a good transition, Kevin, into just looking at all of this as it's been laid out. What do prosecutors do who are interested in, of course, themselves being ethical, but also training incoming prosecutors to follow the best practices? And I think we heard from Vince about an office that really responded in a pretty robust way by putting someone very seasoned in charge. And then we just heard Jessie talk about how they offloaded the notification process onto someone who is extremely junior, which is not to excuse what she did, but it also is kind of a signal of how seriously they were taking it.
Well, where to start? I've got the special advantage in this panel of having not been involved in either one of these scandals. And although my elected district attorney is partnering with the Attorney General on conviction integrity issues, and will be part of that. But we, as a prosecutor in Massachusetts who is a member of the criminal justice section, I'm here to tell you my views. These are my views. They're not the views of the Middlesex district attorney. They're not the views of the Attorney General of Massachusetts. But my views of this nightmare and where, what are we going to do about it? Because this is a nightmare. And in a room like this with people as talented and varied as we have in this room, it's going to be a number of people with special interests. And one of my particular interests is James Joyce. And Stephen Dedalus in Ulysses said that history is a nightmare from which I am trying to awake. And so I guess I have the benefit, unlike these guys, of not being involved, but I'm still in the nightmare. And how are we going to wake from this nightmare? What are we going to do about it? And so I think there are some things. I see there are some prosecutors or former prosecutors in the room, including Kerry Collins, who is the legal counsel to the Massachusetts State Police, former Middlesex prosecutor. I'm sure there are many others. So these are things that occur to me that maybe we ought to think about. First of all, we need to prosecutors should consider reviewing internal mechanisms for deciding whether exculpatory evidence should ever not be disclosed. What is the decision-making of the line prosecutors when it comes to that decision? What are the supervisory processes that go with that? How and when can exculpatory information ever not be disclosed? And consider the use of the court in tough cases. There are going to be instances where there are questions of actual privilege that might be balanced against the need to constitutional requirement to disclose under Brady. You can use the court for that. There needs to be layers of review to have in place in making these decisions of not to produce exculpatory evidence in a case. Consider retrospective reviews of instances in which there has been a failure of such disclosure, and especially in cases where courts have pointed that out to us. Take a look back and see, well, how did that decision get made, and what was the way in which it was made, and who helped in making that decision? So that's one thing. Training, obviously. You go to the SJC and you hear the arguments, and the courts say, well, every prosecutor knows their duties under Brady. Well, that might be true, but it might not. And one of the things that's being proposed is something that we have here in New York, which is a standing order that is going to remind prosecutors of the specific what Brady really is. which can be broader than what some prosecutors might want to think. And not just training on Brady and Giglio issues, but also and the rules of procedure but also on ethical obligations, which can be broader than Brady. And that's one of the things I'd like to highlight for us here today. Rule 3.8, the ABA Model Rule 3.8, which is also the rule in Massachusetts, requires the production of all information known to the prosecution team that tends to negate guilt or mitigate the offense. It's not just material that the prosecutor might view as material to the defense. To the defense case, as that term might be used in the post-conviction context under Brady. It's not just what the prosecutor might think is important for the defense in this case. It's all material under the ethical rules. The prosecutors, we train prosecutors as best we can, and all prosecutors know this. We try as hard as we can. But there's nothing wrong with a little reminder about the scope of the Brady duties, as well as the duty to inquire of other agencies that are part of the prosecution team. For instance, the police. I'll have a little bit more to say about that later. Consider when there may be a duty to investigate, not just to turn it over. Okay? We know that misconduct by a prosecutor triggers a duty to investigate. Well, what about misconduct by a forensic investigator? And what is the legal doctrine that imposes a duty to investigate in that case? Does it exist? Well, it's not Brady, right? It's not going to be Brady that's going to cause you to launch an investigation into why it was that this forensic investigator did what she did. Right? It's going to be something else. It's going to be the ethical rules. And maybe it might be something like Rule 8.4, having to do with maintaining the integrity of the profession. Doing something, when can inaction amount to conduct that is prejudicial to the administration of justice? The Supreme Judicial Court is very concerned about this. You can't turn a blind eye. Prosecutors, we don't want to turn a blind eye. But what is the doctrine under which we should operate? And this would apply obviously to misconduct like we're talking about here, but on the part of the forensic examiner, but also the same would apply to a police officer who's caught planting evidence. What is the doctrine that requires investigation of that? Prosecutors are going to want to do it and will do it, but why? Make sure that the lines of communication stay open. And this is a great forum for talking about this. It happens so often, prosecutors know maybe you didn't quite ask the right way and you didn't get all the material that exists in a case until the middle of trial. It's very embarrassing. It can be prejudicial to the defense. It's a problem. Well, we need to do better in that area, and we can do better. The relationships between police, the prosecutor's office, forensic experts, there needs to be a chain of command that enhances the sharing of information. And we should be thinking, where might potentially exculpatory information exist? Where would I look in files that aren't my files, but somebody who might be viewed as part of the prosecution team? Investigative agency files, police files, confidential informant files, crime scene investigation files, parallel investigations, such as in the Farrak case. Case-related communications. Where might potentially exculpatory information exist and ask for? These are things that prosecutors are going to want to think about and doing more of going forward. We want to be able to create an environment that encourages prosecutors to report issues. I consider this, again, this is just me talking here. But for me, this is something that we can do better around the country on, and we want to do better. So this is a case that's going to cause us to have to do better, I think. You think in a case like the first person, who's going to be the first person to notice some kind of a problem in a case? It's going to be the grunt ADA. It's going to be the line prosecutor who notices something wrong. 5 bags got sent out to be tested and 6 came back. What? Huh? Why? Well, you want to have a culture and procedures consistent with the rules of supervisory attorneys to a mechanism so that the person can say, hey, I found this discrepancy. Has anybody else seen it? Would someone look into this? Can you help me? So, what happened in the Farrar case is a nightmare. It's not over. It's maybe the beginning of the end, but it is not over. And, with prosecutorial misconduct, in that case, we're talking about lying to the court. We're talking about deliberately withholding exculpatory information. The findings of the judge in this case are bad, but that's not what usually happens. It's not overzealousness, in my experience. What it is it's overwork and lack of support. That's where we fall. That's where we make mistakes. Overwork people who don't really know what to do with information that they get that ought to be shared. So maybe we ought to start thinking more about the ethical rules on this and what supervisors have in law firms. Supervisors have responsibilities under the ABA Model Rule 5.1, and supervisory authorities in government agencies do too. So what do we do with that? What should that look like? How do we take reasonable steps to ensure that people we are supervising comply with their duties under the ethical rules? And also to make sure that non-lawyers don't violate constitutional rights under 5.3. These are things we're going to have to think about. You can't just stop at the case always. Sometimes, because as I said, ethical duties are not coextensive with constitutional principles like Brady. Sometimes you have to drill down. You have to investigate. And you can't just look at the constitutional issues. And you need to address it proactively. We've had, for instance, when we know that there have been mistakes, we have tried often to address it proactively. The criminal justice section, out of the criminal justice section came a resolution on microscopic hair analysis, where the Justice Department took a very proactive approach. We applauded them for that, and we would hope that the Justice Department would continue in that proactive, collegial, collaborative way of addressing errors that take place. So there's room for collaboration in this area. Obviously, there's special problems that exist when we're talking about forensics and expert testimony. It's really possible if you're a prosecutor to neglect your duty to produce Brady material if it's in the hands of a forensic expert. In your jurisdiction, you want to look at your basic discovery package. What does that include? Does that include, the electropherogram results? Does that include the bench notes? Does that include correspondence? Some of those things might be Brady. If the defense attorney, that may not be the subject of mandatory, probably isn't the subject of mandatory disclosure under the rules of procedure, the basis for expert testimony. And if the defense attorney has to file a motion, there's going to be a delay. What do we think about that? Speedy trial rights are going to be implicated. The right to a speedy trial is going to be told. The counting of time. What do we think about that? So, whenever you're talking about the results of scientific testing, it should not be left to the individual assistant district attorney on the front lines with a caseload of 300 cases on her own to determine whether there's anything exculpatory in that forensic analysis, right? That's just common sense. How is she going to know? So prosecutors really ought to consider, and maybe they will start to consider, the mandatory or automatic disclosure of the scientific bases of experts' opinions. Maybe that's a good idea. We should talk about that. The instrument readings, are those produced? Because we're just lawyers. We don't know what you guys know, and forensic nonconformance is very difficult, even for experts to discern. Just if all you're looking at is the analyst's conclusions, you need the raw data. The lawyers need the data, and they need it early, and they need complete data in order to the underlying forensic evidence to have complete confidence in the process, and that's what we're talking about here in Massachusetts. What do we have confidence in our criminal justice system? That's what the Supreme Judicial Court is worried about. You know, they're worried a little bit about this case they got going. But that's not all they're worried about. And we need to be able to ferret out unreliable conclusions. So that's something that maybe we ought to think a little bit more and talk a little bit more together about. Certainly anything that might be Brady needs to be disclosed early and well in advance of a guilty plea, for instance. And so all these things are things that we collaboratively ought to talk with each other about, talk with defense, between prosecutors, defense attorneys, prosecutors, and forensic experts. It's wonderful that we are in a forum like this where we can begin that conversation. And I think looking forward, that's something that we're going to need to do a little bit more of. And also bring in the court in from time to time. If you've got a tough case, you know, you might file something, you know, under seal, or if you think it's confidential, or if you think it might be privileged, and have the court look at it. So those are my mile-high thoughts.
Thank you. And Vince, I wanted you to maybe respond to some of what Kevin said and talk about how your office, in the wake of Dugan, is perhaps doing things differently or not, and how the decision-making process was put in place to put you in charge, and whether you had to kind of come up with your own policies to deal with this real crisis, or whether they were in place for you and you felt like you kind of had a foundation, or did you have to almost, you know, go out and create new policies?
So, in terms of how I caught this case, I think they think that I have a Bachelor of Science degree. So
I think you do, don't you?
So at the time, I was working with our first assistant on a case that's a horrible quadruple homicide, and it was an motion for new trial posture. And so we were driving back and forth to a town about 20 miles outside of Boston, where the judge who presided over the trial was sitting when all the Dugan stuff sort of first broke. And as we're driving, I would just sort of, you know, talk to him about what my thoughts on it were. And then one day I showed up, and there was a stack about this high of motions for new trial on my desk from the Dugan case, and with a note that just said, "See me." And in terms of, you know, how we've changed and how we've responded, you know, I think, and you know, you heard about it in the Farrak case. The district attorneys, I think, really behaved, I would suggest, admirably in terms of the way we handled the discovery and everything else. You can disagree with our litigation strategy, you can disagree with our conclusions that we came to under the law, but in terms of the way that we handled the litigation and the discovery obligations, I don't think anyone has a complaint about the discovery. We certainly have a conviction integrity unit within our office at this point. When it comes to...
Is that new, or was that in existence?
No, I think it's in the last... It happened after this, but it wasn't really in response to this. You know, it was... Because that was focused on... That's more focused on the homicides and rapes and sort of our higher profile cases. And then, you know, in terms of DNA testing, when defendants petition under a statute that we have for DNA testing post-conviction, we never oppose those. I actually suggested it once to a defendant who was raising a claim, and he asked me not to. You can guess what the results were of that. You know, I think we have those in place. I think my concern when I look at it from you know, stepping back is so the failure to produce exculpatory evidence is a subset of a larger problem prosecutors have, which is the failure to produce evidence. Right? The majority of times when we don't produce something, it's usually inculpatory. Like, I show up to trial and the cop says, "Gee, I can't believe the guy wants to go to trial. It's all on video." And you say, "Oh, really? That's weird. Why don't I have that video?" You know, or it's like, you know, when I was driving him back to the station, you know, and he confessed to me, you know, I don't know why he wants to challenge this. It's like, oh, maybe it's because he doesn't know that I know that. You know, so the majority of the time it's inculpatory evidence that we fail to produce, and I would say really an infinitesimally small percentage of the time it's anything other than just negligence on the part of the ADA. I think it's usually excusable negligence because of the other part of this, which is, if you've never done prosecution before, and I'm not talking about our federal prosecutors, I'm not talking about people who did you know, defense work for a time and then went to go do murder cases for a prosecutor's office. I mean, if you never did day in, day out, misdemeanor court, 300 caseload, then you don't understand the notion of what I call the myth of the unitary executive. You think that cases come to us, not the case, right? Like someone files a complaint, and then we're stuck with a case, and then we have to go find out what it's all about. Evidence doesn't get pushed to prosecutors in many jurisdictions, particularly in Massachusetts. We have to pull it. And when you have, in my county, for instance, 36,000 criminal cases last year, in my court right now, my 6 lawyers have over 1,100 cases between them. You're simply not able to fully do that. And I think we've reached a point where I think it implicates some ethical considerations, right? Is the workload and the volume so great now that you cannot keep up with your ethical obligations, no matter how hard you try? And I think particularly as discovery has changed over the years, and I'm sure anyone who's been practicing in this room for more than 10 years remembers what discovery was like sort of before the advent of all this electronic stuff, right? I mean, if you tried cases under the old de novo system in Massachusetts, you got a police report and away you went. That was it. There was nothing more to it. And frankly, even when I started about 10, 11 years ago, police report 911 tape. That's about all there was. And then maybe if there was a drug case, you have a drug certification. But now, particularly with the advent of body cams, right? So now every case has a video if there's a department that has a body cam. Every 7-Eleven and storefront has a surveillance camera. There's DNA analysis in theory in every case. It drives me nuts when the police submit for touch DNA a gun that was found in a guy's waistband, right? It's there. So it's not as simple as just having the report and away you go. And I think at a certain point we have to figure out how structurally can we change the discovery practices and the evidence collection and collating practices so that we can keep up with our ethical obligations.
And Jessie, I wanted to ask you about this request for monetary sanctions and sort of what that came out of and what the goal behind it is, because it is an extraordinary remedy to ask for, and then maybe, I obviously know that you can't predict the future, but where you think that argument might be going in the SJC.
Sure. So the kind of background principle is that it's very difficult to hold. So I should start from most prosecutors perform their duties ethically, but it is very difficult when they do not perform their duties ethically to hold them accountable. So, maybe in the individual case, the conviction gets vacated, but that doesn't really impact the prosecutor so much. They have one less conviction. Maybe a ethical complaint is filed against them with the state bar, as happened with the 2 assistant attorney generals in Massachusetts. But there's because of prosecutorial immunity, there's really no way to hold prosecutors accountable, and even more so, no way to hold the offices accountable. After the Supreme Court's decision in Connick, a prosecutor's office cannot be held civilly liable for a failure to train prosecutors properly. So we were the brief that we filed was a way of getting at the issue of not just individual accountability, but institutional accountability, and a way to incentivize prosecutors' offices to actually put in place the kind of things that Kevin was talking about, the kind of procedures and processes that will actually standardize decision-making and increase oversight, and perhaps even increase resources. And so what the parties had asked for in their filing with the SJC was the possibility of monetary sanctions. And it is a pretty novel remedy. And frankly, we gave the court some suggestions of the authority by which it might order monetary sanctions against the Attorney General's office under Rule 11 or under Rule 48 or even under the court's inherent supervisory powers to sanction the Attorney General's office, and provided examples that, for example, when an individual lawyer commits at a law firm, and at my private law firm, your law firm can be held accountable and sanctioned as well as the individual lawyer. So why should that not also be true of prosecutors' offices. So I will say, I'm not super hopeful that the SJC is going to actually agree with us that monetary sanctions are appropriate in this circumstance. And and frankly, among friends here, it's not quite the most effective remedy either, because essentially it's taxpayer dollars in the end, right? It's not like when you sanction a law firm and it's actually coming out of the law firm's profits. You're sanctioning essentially a public entity that's going to pay it out of a judgment fund or something like that. But it at least is some kind of symbol. And even if the SJC does not actually agree with us on issuing monetary sanctions against the Attorney General's office, we wanted to get across the point that contrary to the position that the AG's office has taken in its briefing in the SJC, this is not just about two rogue prosecutors. This is about actually holding the institution accountable for the decisions that the institution itself made, not just a couple of bad eggs who kind of were off the reservation doing something they shouldn't have. So that was kind of the point of our brief.
And that actually leads me, Kevin, to my last question before we open it up for questions. And that's really a question about office culture, because I feel like that's at the end what we're really talking about, and whether line prosecutors who, as Vince said, may be quite overwhelmed, and as Kevin said, maybe less than perfectly trained, feel like they're operating in a system where if they are uncertain or they do have questions or they feel like, well, maybe I do have to actually just toss this case even though the guy is good for it because there's been this issue, they feel comfortable doing that, and they feel that the office culture is going to support them being very vigorous and robust and respecting their Brady obligations. And I think it kind of varies between offices about how they operate under Brady and how vigorously they train, and also how they interpret it. And I tend to, Jessie, I'm not sure if this is your point, but I sense that it was, and I agree, which is I don't think these two individuals, Ann Kazmarek and Chris Foster, were just out there on their own. I mean, along the way, they had all kinds of institutional support, and for years, what they did was defended by people above them in their office. So there's obviously a culture there that is a huge problem, and as Kevin said, just creates kind of a nightmare for everybody afterwards that we're all stuck dealing with. And so I'm just curious about this idea of how you change institutional culture such that people feel that they're in a work environment where it's not just accepted, but sort of supported to be very, very vigorous about disclosure. And I say that because it seems like the other way to go about it is through kind of almost like a public shaming, right? Because a monetary sanction against the Attorney General, that would be quite shameful. Or, what I've written about, what the Ninth Circuit does sometimes is, they shame prosecutors in these wrongful conviction cases, and they use oral argument to really go after them, and then people watch the oral argument. It's very shameful, and depending on how many people watch, if it gets big enough, maybe they'll actually end up abandoning their case. So it seems like on the one hand, we have this remedy of kind of like calling people out and shaming them, and on the other hand, we have, I think, what Kevin's working on, which is a much more kind of proactive remedy of, can we institute a culture and practices in the first place where we're going to be dealing with this less on the back end?
Let me first stick up for the AG's office. The judge in this case made findings about what happened. And what happened was the supervisors were lied to in this case. The evidence is that these were two people who committed egregious prosecutorial misconduct, but they lied to their supervisors about it, okay? Now, I don't blame that I don't infer from that there is necessarily a culture that is supportive of lying. I don't know what is going to come out of that in terms of shaming. When this decision comes out, when the published decision of the Supreme Judicial Court comes out, that is going to be shame like we've never seen shaming. Because we know about this case. You guys know about it now. Maybe you didn't know too much about it before. But the world at large doesn't know too much, even though it's been on the cover of the Rolling Stone. The world at large may not know as much about it as we do. And to me, what the problem is that mistakes happen. Prosecutors are capable of egregious misconduct. And prosecutors, I mean, we got good prosecutors in this room. We've got good analysts in this room, you know, principled, hardworking, dedicated public servants in this room, and we are defensive when our integrity is impugned broadly. And you know, I think it's going to be very difficult for prosecutors to take that reaction to in a case like this. And I don't see prosecutors taking that reaction in this case. I think that there's great leadership in the Attorney General's office. There is a strong commitment to take the steps that are appropriate and necessary to develop the culture that you're talking about, Lara.
And I should say there is a new Attorney General. So Martha Coakley is no longer the Attorney General, and she was overseeing the office during much of
Maura Healy is currently the Attorney General, and she for instance, she has agreed to co-chair together with District Attorney Marion Ryan of Middlesex County a working group on conviction integrity that's going to be statewide, that's going to be collaborative. It's going to include not just prosecutors, but also defense practitioners, academics, civil rights practitioners, hopefully other specialists. You know, this every once in a while, something like a case like this comes along, and everybody just has to stop. How could this have happened? And there's clearly a need to. Nobody wants it to happen again. That's for sure. But fond words of hope aren't going to be enough, and nobody thinks that. And we are seeing now in the Massachusetts Attorney General's office, based on the briefing, I don't know, again, I don't speak for the Attorney General, but based on the brief that's publicly available, a significant commitment to the types of things that are going to be necessary to just enhance our quality control. Things kind of do fall apart if you don't take care. And we're, as Vince has pointed out, and Jessie also, we're now at a stage where things are becoming, criminal litigation is so much more complex due to the forensic issues that are involved, as well as to the workload and the reduction in public resources relative to the workload. So this is a time for collaboration among prosecutors and defenders, among civil rights activists, among members of the judiciary, among experts in the field. And this is where I hope we are going to. This is what we're looking forward to. And that's different. That is different. And I do believe that that is something that's going to lead to a culture that we can be more proud of. You know, where the young prosecutor can be proud to present this anomaly to somebody, knowing that it's going to be patted on the back, and it's not like, oh, geez, now you've created more work for us. And apparently, there was, in this case, with this one person, that was her perception. Her perception was, I want to put my finger in the dike so that we don't have 10,000 more motions for new trial out of the Amherst lab, like we did in this Dukin case. Because, in my view, this is just someone stealing drugs. This isn't anybody messing with the composition of the substances. And, due process shouldn't, we don't need that, because I know better. Right? So, how can that happen? I don't think it's a culture of in that office, because I know that office, and that is a proud office. That is an office with proud history. I've got a lot of friends in that office, and I'm proud of the work that office does. But there is no prosecutor who's going to be proud of what was done by these individuals in this case.
So yeah, I wanted to open it up for questions in the time that we have left. Yes.
Good question. Were all the cases from the Amherst laboratory vacated?
No, at this point, just the cases in which Farrak was involved have been vacated. And part of the remedy that the SJC is currently considering is that they have asked that all cases be vacated that went through the Amherst lab during that time period. So I think it's about 8,000 convictions have been vacated in which Farrak had some involvement, but not every case.
So
There were other cases.
28,000 cases have been vacated between the two.
That is the math, yes.
Yes.
So why were all these jurisdictions using laboratories that weren't accredited?
So the answer to that is in the 1970s, the legislature placed the lab under the auspices of the Department of Public Health. And back then it was the Food and Drug Lab is what they called it. And it wasn't even just purely designed to test for criminal cases. There's actually a statute that requires that before any narcotic or suspected narcotic is destroyed, it has to be chemically analyzed first. So, 5-year-old kid at the playground finds 2 bags of heroin, calls mom over, mom calls the police, they come, they take the drugs. That has to go to the lab to be analyzed before it can be destroyed, by virtue of the way the statute works. And I think 2 reasons. I was not part of the legislative history of that decision, but I think one was there was a hope that would be, by taking it away from the police, it would be independent evaluation, right? This is a tension I think that exists today still is, should the police be involved in the testing of the drugs, or should it be a civilian organization? This is one way the civilian organization can go wrong. And I could talk for hours about, I think, the way the DPH lab really misunderstood what their mission was in terms of what they were supposed to be doing. Which in a way that I think the state police really gets. The state police is like a paramilitary organization in Massachusetts. And I mean that respectfully, like they're very, very, very squared away. And I think they are literally a paramilitary organization. But so they understand the importance of chain of custody and all those things, whereas DPH was more about just getting the analysis done and moving on to the next one. And I think also it was under their umbrella because I think that was one of the things they wanted to know was what's out there. As a public health question, what's out there, not merely what's being seized in criminal cases, but what's being found on the street, what's being involved in overdoses and suicides and things like that.
And that other lab is in a university. What's that about?
Well, it's still the Department of Public Health, but it was housed at the University of Massachusetts. So it was a laboratory, it was a building on the UMass Amherst campus.
Yes.
This is kind of an out-of-the-box question, but so much of Brady violations are usually in violent crimes and other types of prosecutions. Drug cases are not the norm and largely go undetected because misdemeanor cases almost never go to trial. And as I was sitting listening to the presentation today, I was thinking about the volume issues that really made this the issue probably as much as anything else. And I was wondering if there was any serious discussions as a different type of prophylactic matter to stop prosecuting so many low-level drug cases. Given where we're going with drug reform and marijuana legalization and all the rest, that this probably could have been avoided if we were only going after major cases.
Maybe. I think Massachusetts, I think we're 49th in the state incarceration rates. I think we're on par with the Netherlands.
Right, that's why I asked the question.
We're not sort of real heavy on that. And I think as a matter of practice, because of the backlogs that exist at the lab, frankly, we don't prosecute we don't prosecute possession cases in Massachusetts. That doesn't happen. If you're indicted, you're going to get prosecuted, according to what the statute requires. But in practice, if you have a straight possession, which is the majority of your drug cases, as a matter of practice, you are not. There's a dog and pony show we go through for about 4 months until the case is dismissed when we don't have an analysis done at the end on the day of trial. But that's you're not really being prosecuted.
So all those cases that were dismissed are well written.
The 20,000?
Hey, it's a different time period. This, because keep in mind, much of this was pre-Melendez-Diaz, right? So, the backlogs really surged after Melendez-Diaz.
But I mean, many of them, it was a mixture of everything. But certainly, it's not to say that in 2008, people were not being prosecuted for straight possession. Hardly anyone goes to jail for it. But there certainly were those cases, yeah.
I heard about all these cases being dismissed, and I kind of was just like, who cares, right? I mean, it's not a public safety issue, and they just kind of went away. And it's just like, doesn't it feel kind of...
Well, some of the people who were released from prison have since been indicted for murders, have themselves been victims of murders. There's those many of those convictions are predicates for enhancements, including armed career criminal in Massachusetts and in the federal level as well. I don't think it's fair to say that there's no public safety aspect involved at all in narcotics prosecutions.
I'd like to respond and do something that, Chris, your point touches on, which is it just goes to show addiction, the problem of addiction in our society, how widespread it is and how devastating it is. And, the policy that we have in this country for addressing it, it's, when we as prosecutors see it and we feel it, we're trying to deal with this huge social problem with the crudest of tools. It's like trying to fix a television set with a billy club. And there's very little that prosecutors can do to address the underlying problem that leads to illicit drug distribution. And we're thinking about this more and more now. When you see someone who is a professional so completely controlled by her addiction, when you read the findings in this case, it's absolutely stunning. But she's not alone in that. She may be a rogue chemist, but there are many, many others in our professions who are struggling with addictions right now. So what are we going to do about that? How are we going to address the demand for illicit drugs? I think that that's something that's worth thinking about too.
And I think it's easier said than done, particularly if you don't actually have to sort of do it day in and day out, is to say, well, wash your hands of those cases and just don't do drug cases. And then when you have, the families following an overdose come to you and ask why you didn't do more, or you have the externalities that come with a lot of those sorts of crimes, I don't really care. I take off my DA hat and put on my Vince hat. I don't care about these cases, right? I agree with you that the law enforcement objectives that can be satisfied through straight possession prosecutions are limited. But the reality is it's not that. It's the car breaks. It's the home breaks. It's fencing the stolen property to pay for it. It's all the larcenies from the stores. There's the domestic violence aspect that gets wrapped up into it. There's a lot of externalities that come with drug addiction. And we don't have much of a choice. We're the backstop, right? All of society's problems, mental health issues, substance abuse disorder, all those things that everybody else fails to fix, doesn't want to fix, or just wants to ignore, they become our problems. And we get no tools in the toolbox to fix them except putting someone on probation and forcing them into some sort of treatment. That's, I think, one of the dilemmas that the system faces is exactly that.
Just one final question, and then I swear we will get to drinks. So, Henry. I want one too. Yeah.
Yeah, Henry. Sorry, Henry just had his hand up first.
First, thank you all for a very good presentation. I have just one question and one comment brief. Perhaps I missed it, but what happened to these two prosecutors who you stated lied to their supervisors and were reported? Is that the question? And the comment is, in terms of stepping out, in terms of culture, I think a lot of people have forgotten that when Clarence Earl Gideon's case went to the Supreme Court, the Florida AG asked AGs around the country to file an amicus brief on behalf of denying Gideon's petition. And several, including the Massachusetts AG, the Minnesota AG, Walter Mondale, Missouri AG, Tom Eagleton, they got like 25 and they stepped out and said, no, he deserves it, and only one other did. And that was a way to start to change a culture in some places, because they said they weren't going to go along with what the Florida AG said.
Jessie, did you want to speak to what happened to Ann Kaczmarek?
Sure, and Kevin may have more of the details, but they are, as I understand it, both still employed by the state in other capacities. I believe Kaczmarek is now counsel at the Bureau of Alcohol.
No, the other way around.
Oh, sorry, Foster is at Bureau of Alcohol.
Yes, one of them works for another state agency, another works as a clerk, a court,
To a magistrate.
The trial court.
she's a clerk magistrate in a trial court.
Did prima facie a criminal offense? I mean,
So there
wasn't
isn't-
it obstruction of justice? I mean, I don't get it.
You know, this is why we need to look closely at the ethical rules. You know, the ethical rules talk about the duty of the prosecutor to produce. You know, so, are you the prosecutor? If that's not your case, I don't know. But in terms of lying to the court, violating the duty of candor to the tribunal, all that stuff, those are being investigated. It's not. They are entitled to due process.
Well, I don't get that. I'm just asking if it didn't appear to be on its face obstruction of justice under normal principles that apply to that crime in most jurisdictions. Maybe Massachusetts is different.
Yeah, I don't think we have that.
Why the problem you run into, because I stepped across the case or attempted to, that involved investigators from law enforcement agencies, prosecutors' offices, and the elected prosecutor in a jurisdiction for a Brady issue. The problem with some of the statutes is that the obstruction of justice charge was created with a bias in the legislature. And that bias is that it's going to be the defendant's families, friends, or defense counsel that are going to be guilty of it. And it's not going to be law enforcement, it's not going to be the prosecutor. And that's the problem that you sometimes run into.
That is a problem.
I will say just before we end that they are under investigation by the state bar, and it is interesting to see how certain state bars have become more proactive and aggressive about sanctioning prosecutors and defense attorneys who engage in extremely egregious conduct. So they could end up getting disbarred, as Kevin says, they are entitled to their due process. But it'll be interesting to see what happens as a result, and if that's part of kind of a growing movement for the bars themselves to be more assertive about disciplining people who really go off the reservation.
Can I just say one last thing? And talk a lot about the culture of the offices. So I feel pretty blessed to work in the office I do in terms of the culture that we have. And for prosecutors here in the room, the one thing I would sort of take away from it is that as I tell I'm also really lucky to be able to train my kids, I call them. They're young, 26, 27-year-old lawyers, brand new out of law school. And I teach them on day one that this is a process-oriented business, not an outcome-oriented business. And I remind them of that virtually every single day. And if they get a not guilty or an acquittal back on a case, I say, oh, that's a bummer. What are you going to do next? Let's move on. And you don't let them dwell on it because it doesn't matter. So long as the process is done correctly, that's all that counts at the end of the day. Outcomes do not matter in the criminal justice system.
Thank you so much.